Our next panel is on financial firms in the SEC's crosshairs. We're going to be talking about asset managers, broker-dealers, private funds, hedge funds. This will be a really interesting discussion. And let me start off with our representative from the SEC, Ann Blazek, Assistant Director in the SEC's Division of Enforcement. She has served in the Chicago Regional Office for over 12 years and has also been a member of the Asset Management Unit. Welcome, Ann. Thank you for joining us. Next to her is Ann Gittleman, a Managing Director in Kroll's Expert Services practice based in New York. Ann is a CPA. She has over 15 years of experience providing expert forensic and dispute assistance in fraud and white-collar investigations. Ann, great to have you with us. Thank you. Next is Kurt Gottschall, partner at Haynes & Boone in Denver. Kurt joined Haynes & Boone after a 22-year career with the SEC. Most recently, Kurt served as the director of the SEC's Denver Regional Office. Great to have you here, Kurt. Thank you. Next up is our moderator, John Sikora. He is a partner at Latham in Chicago. Prior to joining Latham, John spent 16 years at the SEC, where he was an assistant director in the Chicago Regional Office and a member of the Asset Management Unit in the Enforcement Division. Welcome, John.
Thank you.
Finally, I'm very pleased to welcome Chuck Smith. Chuck is a partner at Skadden here in Chicago. He's an experienced trial lawyer who regularly represents many companies and individuals in SEC, DOJ, CFTC, and FINRA enforcement matters, among others. Welcome, Chuck.
Thank you.
All right, let me turn it over to John Sikora.
Thank you. Appreciate it, Bruce. And welcome to everybody. We've got an exciting set of topics to cover. I thought we'd start with the elephant in the room. I think it's already actually appeared on the directors panel, but we'll talk about it again. We're going to give you maybe an uncut, more unvarnished version of a perspective here. The off-channel communication sweep. So, Chuck, what's been your perspective on the sweep so far? Where it's been and where you think it's going?
I have no crystal ball on where it's going other than there clearly is going to be another wave of settlements announced here shortly. Those will involve broker-dealers, but clearly investment advisors as well, I think, to a larger scale on the investment advisor side, just based on the number of firms that we're aware of that are subject to the investigation. I thought on the last panel, Mary Jo Gillette pulled her punches a little bit, understandably, given the rest of the panel, on whether there's a real hook in the rules for getting at the investment advisors to the same extent that you can get after the broker-dealers. Remember, the broker-dealers have an obligation to preserve everything related to the business. And that was rampantly violated at pretty much every firm and probably every firm. And if your firm has not been investigated and you are a broker-dealer, an investment advisor, a swap dealer, future FCM, either the SEC or the SEC, possibly FINRA, although we haven't seen much there, or the CFTC is going to go after you. And I want to just touch on the CFTC for a second, because for lawyers like me, the CFTC's regulatory hook for these matters is even weaker than the investment advisor hook that the SEC has. Somebody said when we were waiting, none of that matters because the fact is enforcement takes the position that it has the right to go after you for these things. So investment advisors take it seriously. If you are regulated by the CFTC, take it seriously, notwithstanding what the rules say. And you'd better with the CFTC, because if you look at the August 2023 settlements, the SEC settled with 11 firms. About half those firms settled the same day with the CFTC, and the CFT settlements for all but one of those firms were larger than the broker-dealer settlements with the SEC. And it appeared not to bear any relationship to the size of the swaps business or futures business of those firms. That's what I can't figure out looking at it from the outside. It appears that the CFTC is extracting a larger pound of flesh for a smaller piece of the business with a weaker regulatory hook. But the fact is, if you have that business line, you should be really wary. And I'm sure Ann at the SEC will quibble with my statement that the investment advisor hook is weak. But I would say one thing, if you're in the IA business, look at the SIFMA letter in January to Gary Gensler about that statutory and regulatory issue, and you will see, I think, a very cogent argument on why that is a much narrower window. And then you'll realize that it doesn't matter because that's not the staff's interpretation.
And Ann, maybe you could speak for yourself on this. As far as the investment advisor, books and records definition, has the staff been? We have our experiences with these cases, but what's been your experience as to the staff's receptivity to, taking a different view of the record-keeping obligations and a view that those might be more limited than they would be for broker-dealers?
So before I start, I want to say that my remarks today are in my official capacity as an assistant director in the Division of Enforcement and do not necessarily reflect the views of the commission, the commissioners, or the other members of the staff. And so what I would say generally is that as an enforcement staff member, we are always receptive to arguments. We want to make sure that when we're bringing a case, we actually do have a good legal underpinning for it. So, you should feel empowered to come and explain if you think that our interpretation of the rules or the regulations is wrong. Obviously, in the case of the off-channel communications, there are public orders already released against the investment advisors. And so I think we're pretty confident right now that we do have the legal grounds to be bringing those actions. But it's certainly something that is always, worth discussing if you think we've misinterpreted it.
Well, that's great. So, Chuck, with your clients, back to you. You're back on the hot seat. With where things stand with the off-channel communications cases, what are you advising your clients that have not yet been contacted? So in this audience, we may have some people that have not. Are you saying, look, it's a matter of time, just prepare yourself and get the checkbook out and you'd be poised and ready to sign that check? Or are you saying, it's no worries. If you haven't been contacted yet, the dragnet didn't reach you, and you can sleep well at night and never having to worry about this again, or something in between?
I've been sitting with a client in the Midwest over the last few weeks, answering that question for them. I'm definitely not saying they're coming for you, get a checkbook out. What I'm saying is they're likely coming for you. If you look at the size of firms, right, there's some smaller firms in the most recent mix. I think that'll continue. Investment advisors clearly going to expand. Maybe we're wrong. Maybe the sweep will magically disappear, but I doubt it because people are making a lot of money. So what can you do on a relatively clear day for your firm to make the outcome better for you? You can get folks to take it seriously. You can enhance your compliance. You can enhance your tone at the top. But really, you can implement the technological solutions that force communications on channel to the extent possible so that you don't have the issue, so that you can point to the fact, as did one of my clients this year, that, hey, yeah, we acknowledge we had all kinds of issues during the pandemic. We identified the problem. We were aware of the sweep. We implemented technological solutions, and those solutions are working. And we believe we are getting credit for that in this next round of settlements. We'll see at the end of the day, but that's my advice.
So we're going to try to play a little bit of Crossfire. Remember that show? We're going back to Ann Blazek for a moment. So not to respond exactly to what Chuck just said, but he mentioned the size of the firm, right? Which, for those of us on this side of the table, that seems to be a very big driver for example, the outcomes you can expect in the sweep. And maybe the conduct itself is less so of a driver. Anything you can, and if you feel uncomfortable saying something, that's fine too, but anything that you could say on that point I think would be helpful to the audience.
Yeah, I think penalty size has been large in these off-channel communications cases, and part of it is because from our perspective, the violations are serious and they have a real impact on our ability to exercise our oversight in, when dealing with regulated entities. But we also, I'm not going to talk about any individual cases, but generally in setting penalties, we want to make sure that they have a deterrent value. And so the size of a firm can impact what size of penalty would actually have a deterrent value. And so we are considering that. It is an important consideration in setting the penalties in these matters.
Yeah, and I'll throw another curveball at you, Ann, if I could. So having been on the other side of a call with the staff where we were told that the demand for the settlement demand was non-negotiable in one of these cases. Just a question, is the staff open to negotiating penalty amounts in these matters?
So I think that that's an individual case-by-case set of circumstances. So there may be instances where if you're dealing with the staff, they may come in and tell you this is the penalty amount, and we aren't going to settle for anything less than that. There may be other instances for individual reasons where the penalty may be more negotiable, but it is, I think in these cases in particular, there are a lot of them out already. We've already brought 30 actions, and so there is a matrix that we're dealing with and making sure that each firm is treated fairly compared to all of the other firms that have already come through.
And back to something, Chuck, that you said before, which is technological solutions. I think a lot of people in the audience, a lot of clients are both those who've been in these investigations and those that are anticipating that they might get into the investigation in the future. They're grappling with what's out there technologically. How are we going to get past sort of the honor system, which apparently doesn't work for the staff? Is there what are you seeing and hearing about technological solutions and approaches to surveillance that you think might be effective strategies for clients that are in that position?
Well, and you mentioned a point, right, which is surveillance. You can implement technological solutions, but I'm not aware of anything that's perfect. There's still some honor system. People still have personal devices, and they can bypass the system, and they're going to be found out. Surveillance, I think, is part of the key for the firms that are still sitting out there and haven't been subject to the sweep. Is look at what your technology is telling you, and if it doesn't make sense, right? If you have a senior person who should be communicating with their team, and you're just not seeing it in the numbers on the channel, then something's going on. And that may be worth sitting down with that person and explaining that although these settlements haven't identified individuals by name, they've identified individuals by very specific position descriptions. And I will tell you, I've represented individuals in some of these matters, and I get more phone calls from the investment bankers who are being subject to having their phones reviewed in this sweep as you get closer to the settlement, and they are upset about the fact that they may be identified in a way that will be apparent to their friends in the industry. It is probably the most powerful deterrent of some of these folks, because some of it's all about ego, right? And comparative ego. And so I think that surveillance, and I think one-on-one conversations with the notorious violators, and usually the head of compliance has a pretty good sense in the smaller organizations of who the notorious violators are.
Yeah, no, and that's I think that's good. Those are good observations, Chuck. What about what are you seeing as far as like the downstream consequences of these settlements? The effect of the emissions. One aspect of these settlements is that the commission staff is going to get a pretty granular sense of the firm's disciplinary measures, not just as to people that might be named without being named in the order, but as to individuals throughout the organization. What are you seeing about and thinking about in that respect?
Yeah, I mean, look, it's hard, right? Because historically, nobody was complying. And so if you go back and there were, a small number of people whose phones were picked and scanned, but you've got dozens of others who were similarly situated, are you really going to punish those 10 people, to pick a number in an organization? Or are you going to, going forward, make sure that you've warned everybody, right? Okay, we've got the systems in place, you're to do this. If you don't do it, there will be consequences. I think that's really important. It's just like any other compliance issue, except that it's one where there was just rampant violation by everybody in the industry for a long time.
Well, why don't we shift gears and talk a little bit about cooperation? I know it came up on the directors panel, but again, I want to dig a little deeper if we could. So it's obviously it's a perennial hot topic, and it's one that, for those of us on this side of the table, it can be very difficult to explain to clients. In the FCPA space and the DOJ, there's something more of there's more formalized template for what you can expect under the sentencing guidelines and that sort of thing. But in SEC cooperation world, it's much murkier. And Ann, just to Blazek, just to start, if you could, could you help us set the table here? So for starters, what do you consider extraordinary cooperation?
Yeah, so I think cooperation is going to come in a bunch of different categories. The first one is a self-report. That has a big impact on the staff's view of whether an entity or an individual is cooperating. If you know that you have committed a violation, particularly in the off-channel space at this point, then definitely consider self-reporting, because I think that we've seen multiple actions coming out already in the off-channel cases, the HSBC and the Scotia Capital. Those were 2 self-reports, and their penalty amounts reflected that. They had reduced penalties because of the self-report. But then beyond self-reports, during the investigation itself, there are steps that you can take to show the staff that you are cooperating and that you want to be considered an entity or an individual that's cooperating. So a few things that we do find powerful: making witnesses available, particularly on an expedited basis, identifying hot documents, highlighting them for us, offering translation for documents that are maybe in foreign languages, presenting factual presentations during the course of an investigation that are not just advocacy pieces, but that actually shed light on what happened and help us to understand things. Those are all factors that I think are practical, and those are the types of things that we're looking for.
And you mentioned self-reporting being one important consideration. Do you think companies and firms have a shot at getting extraordinary cooperation credit if that begins after they get a request from the SEC in an investigation?
I think that, yes, certainly there is an opportunity for cooperation credit after you get a request from the SEC. There's not an opportunity for self-report level credit at that point, but there are other things that you can do, and we really do consider it on a case-by-case basis. And if you manage to inform the staff in a way that shortens the investigation or allows us to really better understand what happened or the scope of a violation, then that can be taking place even after you get a request from the SEC.
And Ann, not to pick on you, but the Commission's pretty good about announcing these days some measure of cooperation credit, whether it's a reduced penalty or no penalty at all, right? And that is helpful, but those are for announced enforcement actions. What factors would you consider, and what could you sketch out the considerations for when extraordinary cooperation might actually earn a company a walkaway by the enforcement staff?
No, I don't think there is a set list of factors that we consider. It's really the types of things that I already identified. And we do have a robust cooperation program. So one possibility or 2 possibilities through the cooperation program are a non-prosecution agreement or a deferred prosecution agreement. So that's something that I think you could come in and talk with the staff. That would be an agreement that you'd be entering into with the Commission to offer full and meaningful cooperation. Those instances are rare where firms or entities are given a deferred prosecution or non-prosecution, but that is a possibility as well.
So Kurt, now you're on the other side of the table. No disclaimers. Your views might be the views of Haynes and Boone for all we know.
That's right.
But what's been your perspective on cooperation?
Yeah, well, I mean, look, I'm not shy about criticizing my former employer, but
there we go. That's why he's on the panel.
That's why these panels are fun, right?
But I'll start by saying give the Commission credit where credit's due, and I think that they've done a much better job recently, particularly on the cooperation front, of articulating in very detailed terms and orders how to cooperate, how to deliver information to the staff in a factual way that gets you credit. So I think that has been extremely helpful, because there's nothing better when I'm trying to convince a client to take some of these extraordinary measures to put past orders in front of them. That said, look, it's difficult, right, to be able to articulate, much less quantify, what the penalty reduction is. And I think HSBC and the second tier of off-channel communications were extremely helpful, just because there was such a robust body of penalty evidence about here's what you get if you don't self-report, here's what you get if you do. Most of our clients, particularly obviously in the asset management space, are very quantitatively driven. So they're going to ask 2 questions. They're going to ask, what are the odds I get caught if I don't self-report this? And then they're going to ask, what's the delta on the penalty if the SEC comes calling or does not? And I think off-channel communications is a perfect example of this dynamic recently. And I guess I would depart a little bit from something you said earlier, Chuck, that I think, yeah, it remains to be seen whether enforcement's coming for you in the near term. But I can tell you for our clients, particularly in this space, what we're telling them is exam is coming for you at some point.
Well, and enforcement's coming for you as well, because what we're seeing from enforcement recently out of some of the regions anyway is you'll get a request for information that historically would not have said image devices of your team and of the deal team, for example, on a SPAC deal. And yet the first phone call is, give us the team members' names and we want you to image their phones.
Yeah, exactly. But I mean, for off-channel, that's going to be, I think it's been in 100% of the exam requests we've seen this fiscal year. I think that'll just be a perennial request, and they're going to hammer you if you haven't, remediated those issues right now. I mean, I think the only other, one of the most difficult decisions any of us face is whether to advise a client to self-report. And I guess, what I would love to see from the commission, and you're not a policy maker, but you can communicate this to Gerbir and up the food chain, is for non-scienter cases where where there's no investor harm, to just have almost like a ceiling or some cap of what penalty amounts would be. Because one of the things that's most tricky, I think, for clients is to say, all right, I've got, we've remediated the harm, or there was never client harm. Should I self-report this? It's a rule violation. It's a foot fault. And our advice is, yeah, we don't know. It could be, there's a great body of evidence on Perks cases, with Black & Decker and ProPetro of getting no penalty, but you could get hit with a 7-figure penalty on some other rule violation that the commission wants to make a point. So that's the tricky thing, I think, in this environment.
And Kurt, another tricky facet that we deal with on this side of the table is when you're investigating the facts as part of an attempt to demonstrate extraordinary cooperation, and you're in regular contact with the staff, and they want you to report on what you're finding, right? You're conducting interviews that are where the interview itself is a privileged communication. How do you dance the dance to give the staff what they need while making sure that that the privilege is being protected?
Yeah, and look, obviously, another extremely difficult question, in part because the exposure from the plaintiff's bar is not going to be known to you at the time you're making these calls, because there's a lot of plaintiff's lawyers out there who will file a derivative action after the SEC's sued your client. So you kind of have to make these calls in a vacuum. And I mean, obviously, the tried and true method where it's possible is to just deliver the factual information and potentially protect the privilege, because once you waive, obviously, there's been some bad case law recently on oral, waivers to the staff and so forth. So it's you sort of have to assume if you waive to the staff, you're waiving to the plaintiff's bar and proceed on that basis.
Yeah, and Ann Blazek, when defense counsel's in giving you a self-report, and you say, okay, what did the CEO say? What's the CEO's perspective on this? You talk to her, right? Yes. What did she say, right? And the counsel comes back and says, well, that's privileged. How does that factor into what kind of credit you're willing to give the company that's engaging in a self reporting and cooperative dialogue?
So I think it's always a difficult situation, because we do want to be respectful of the attorney-client privilege and not delve into that. At the same time, if we don't have information that would be helpful to evaluate whatever the potential misconduct was, particularly if I've been involved in situations where somebody has come in and said, well, we can't talk about a particular interview because it was privileged, but we can tell you that what we learned there really led us to believe that you don't have grounds for a violation. Well, that's not really very helpful. You can't use the privilege to protect the communications while also trying to put forth the substance or the conclusion from the communications that you had. So in instances where we may ask, there are certainly occasions where we take it very seriously, but we may ask for a waiver of privilege. And if there is a waiver, then yes, that's something that we look at as cooperation from a firm.
So Kurt, let's shift gears. Let's talk about the Advisors Act marketing rule where the compliance date was last year, and really this is in government terms, we're talking about lickety-split, where the government went from the compliance date, which was roughly a year ago, now to a suite of enforcement actions in less than a year, post-compliance date. What's been your perspective on that?
Yeah, and lickety split is a good word for it, among others. But I thought one of the odd things about the marketing rule and how it's played out over the past year has been that right around the implementation date last November, there was a lot of messaging from SEC senior leadership saying, "Look, guys, we know we haven't provided detailed guidance on this stuff. We're all going to figure it out together. Yes, it's going to be a heavy exam focus, but sort of a kumbaya moment from the senior leadership. That has not been the experience, at least of our client base. It is in every exam. It is going page by page through not just QP decks, but institutional investor decks to try to look at some of these provisions. So it's a major focus. Obviously, we all get the same news feed. There was the hypothetical performance sweep announced last week. In case you're on vacation, so 9 investment advisors charged with violating the marketing rule, penalties of $50,000 to $175,000. These were all cases with firms that had hypothetical performance on their outward-facing websites. Which is tricky to do, and look, you could argue that it's a logical starting place, the lowest hanging fruit, if you will, in the marketing rule, because it's the standard requires that not only do you have policies and procedures to make sure the hypothetical performance is relevant to the investment objectives, which arguably you could say, okay, if I've got X strategy and someone's on my website, they're interested in that strategy, but knowing the financial situation of that mass audience is practically impossible. So I think not super surprising. The only other case to date has been the Titan Global, marketing rule case back in August. Again, that case not particularly. I don't know that there are a ton of takeaways for this audience. You had a crypto strategy that had played out over 3 weeks. They extrapolated that strategy and claimed if you did, annualized performance would be in excess of 2,700%. So that was the basis for the misleading fraud claims on that. The marketing rule piece of Titan, again, not adequately disclosing the assumptions, which tracks well, obviously, if you're extrapolating from a 3-week performance to an annualized performance. But the other, I think, takeaway from that is Titan had layered, embedded disclosures talking about the risks, and that's going to be a no-no under the marketing rule. So, obviously, have your clients scrub those links to make sure it's all in one place.
And Chuck, what about you? What are you seeing in your practice? One of the things that stands out about the sweep so far is that they aren't household names, right?
No, and that's right. And so I think it's, and I think the household names, the announcement last week, right? It struck me as Lake Wobegon. All the children are above average, right? With hypothetical returns where everybody's going to do well, right? All these hypothetical returns are never like middle of the pack. And so that is low-hanging fruit, as Kurt said. And those are not the most sophisticated firms in the world doing that. They typically, honestly, aren't the Skadden client base. It'll be interesting to see how over time this plays out with the larger firms, and because I don't have enough data points to know that yet. I think I've asked my partners in the SEC enforcement practice at Skadden, and none of us have a lot of, we've seen it in exams. You aren't seeing it in enforcement from us yet.
And Gittleman, let's shift gears and talk a little bit about investment advisor fees and conflicts. This is a perennial enforcement priority in the advisor space, although I think the scope of what's a focus for at least enforcement is also perennially expanding. So what's been your perspective? What have you been seeing in your work?
Yeah, no, fees and expenses, I think, have always been a priority of the SEC in exams, and definitely in compliance departments, an area that they focus on. We've definitely seen an uptick in focus on that particular area, in particular where you have related parties that are performing services for private equity funds, and that often happens, in the real estate context. And there has been a focus to determine if those fees that are being charged are at arm's length. In addition, there could be, multiple funds that are managed by one advisor, and that advisor is charging through their internal costs to each one of the individual funds and their investor groups, which can be clearly different investors in every group. So allocation of those internal costs has become a priority that we've seen in some SEC exams and the like. And so there's been more and more advisors that have implemented sort of time entry or time recording platforms, which I know people are really excited about. And but it really helps in keeping track of what people are working on so that they could really prove that they are tracking their time and allocating it based on internal drivers at the firm. I think also there's been a heightened focus on conflicts of interest, in particular in the mutual fund area, where basically advisors are recommending certain investments and they're getting 12b1 fees from those investments. And there could be alternative investments that don't have the associated fees. So importance there is disclosure, 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 and mitigation, ensuring that you have appropriate controls to mitigate those conflicts of interest, and really staying on top of what you're investing in and making sure that those material facts of those investments are disclosed if there are conflicts.
Thanks, Anna. And Blazek. So particularly in the private equity space, some of the cases, the enforcement cases, have been getting pretty technical, right? Where, like there's the Inside Ventures case that came out recently where you have, the way the enforcement action's drawn up, they're parsing the language of a limited partnership agreement used by a private equity firm. So, what's the definition of a portfolio investment versus a portfolio company? This is all about, impairments and write-downs and write-offs and that sort of thing, and whether it's being done appropriately. I think the perspective on this side of the table is, boy, a lot of this stuff would have been handled, in exams, and now it's coming through in enforcement. And how do you, in enforcement, how do you look at referrals where the referral from the exam program may, say, hinge on really a legal interpretation by, people that aren't lawyers, or if they are lawyers, may not have relevant industry experience, and how open are you to, arguments from, the industry and industry, sort of industry seasoned lawyers with sort of, what they think would be, better interpretations of those documents?
So I think as an enforcement attorney, when a hyper-technical referral comes through, that is a difficult, it's a difficult referral to evaluate and then to go ahead and investigate, because as an enforcement attorney, we are ultimately looking at whether we can actually litigate and win in court. So if you are facing an SEC enforcement action on what you consider to be a hyper-technical violation, if you can explain that to the enforcement staff and demonstrate why they're not going to be able to win in court, that's certainly something that they're going to take into account. But in terms of the general interactions between exams and enforcement, I think that exams is in the field. They're really understanding these businesses and able to help registrants figure out how to comply with the laws in a way that enforcement isn't positioned to do. But there are often circumstances where exams has gone multiple times to the same registrant and raised similar claims or the exact same concerns, and nothing really is done about it. And in that case, that really is something that enforcement needs to get involved in, because we can't have registrants just ignoring exams repeatedly and putting investors at risk.
Thanks. Why don't we shift gears in the interest of time and talk about gatekeeper liability? I think everybody at this event is a gatekeeper in one form or another. And so everybody will be on the edge of their seat for your perspective, Ann, on gatekeeper liability. How do you think about it, with respect to the category of chief compliance officers, attorneys, and accountants?
Yeah, so enforcement is looking at gatekeepers, and I know that can be uncomfortable for people who are potentially in the gatekeeper role. The reason that we are looking is because you play a critical role in, as a first line of defense, ensuring that investors are protected, that the markets are functioning the way that they should be. And when gatekeepers fall down on the job and they don't fulfill their responsibilities, that has real impacts for investors. So that's why we're looking, but I think ultimately our goal is to empower gatekeepers, attorneys, accountants, CCOs, to actually create robust compliance programs and ensure that their clients are following the law. So the enforcement actions are typically what you'll see for any of those categories are really egregious behavior. Looking at the CCO example, 2 Point Capital came out recently. In this case, the CCO was charged, but the firm had just used for 10 years compliance manual for an unrelated business. It didn't have anything to do with what they were actually engaged in. And so that's an example of that CCO really just didn't comply with his responsibilities. So that's the type of instance that we're looking at when we're looking at gatekeepers. And ultimately, we're hoping that our enforcement actions and then coming to speak at events like this will arm people who are gatekeepers with information that they can then use with their clients or with their leadership to ensure that they're not in a position where they have compliance problems or other issues.
And just sticking with the CCO point for a minute, I think where people sometimes struggle, there's the three prongs, right? There's you're involved in misconduct, sort of no duh, you might have exposure. You there's some misbehavior during an exam, false documents, backdated documents, also kind of an easy category, right? And then there's the wholesale failure, right? Is the other prong. Be interesting to hear your perspective, Ann, on how to that's a bit of a mouthful. It's not clear exactly what that means, but how do you what are the considerations going through your mind when you're asking yourself the question, is this a wholesale failure?
I think for me personally, what I'm looking at is, did this registrant have a compliance program that was actually aimed at ensuring that it was going to comply with the securities laws? And so in an instance where an investment advisor is required to have written compliance policies and procedures and they just borrow from another unrelated business, that's not an effective compliance program, and that's clearly not an instance where it was really important to the firm. And so that's something that we really are concerned about.
And we'll get even nearer and dearer to everybody's heart here. What about attorneys? When do attorneys come within the scope of potential gatekeeper liability?
So I think attorneys, it's the same factors apply. I think what you will often see in our cases against attorneys is they're engaged in misconduct where they're taking advantage of the confidential information or the relationship that they have. We just filed a couple weeks ago an insider trading case against a Brazilian attorney who was serving in Washington at a global law firm, and he was engaged in insider trading based on client confidential, non-public information. So, that's just egregious misconduct for anybody, and so we're not going to hold back just because it was an attorney.
Is there anything about, Kurt, any perspective on attorney exposure in SEC cases?
Well, I was actually going to interject on going back to CCO liability for a second, because those are, I think, the toughest gatekeepers for the commission to evaluate. Mm-hmm. Attorneys rarely get into the soup, and when they are, it's usually affirmative misconduct or manipulation of documents and so forth. And I think that broker-dealers, similar, well-traveled territory. But I do think one of the issues that's been troubling to me on this side of the table now is that third bucket. It's a wholesale failure. What does that mean? And I think you're seeing some real kind of narrowing of that, or at least threats of narrowing that by the commission without a lot of explanation. And so I think back to, there's a famous case in 2011, the Biden case, where the CCO had moved to Brazil and was still, signing off on the forms and so forth. Clearly, wholesale failure. There was no legitimate compliance program at that advisor. Fast forward to last summer in the Hamilton Investment Council case. Again, it's a tricky case because you had a president of the firm who wore a dual hat as a CCO, but the commission alleged that he, had a very specific breakdown of not following up on outside business activities by an IAR that ended up misappropriating from the client. And I sort of think of this, to use a football analogy, almost like a offensive lineman, right? If you miss a block and someone runs up and sacks the quarterback, that is a wholesale failure on that play, yes. But he's in the arena. He showed up for the game. What does this mean? I think particularly when there's a negligence-based standard, and Commissioner Peirce has actually had some, I thought, compelling dissents on that. I think the commission needs to be very careful how they parse that.
Yeah, there's a factor of the commission may be focused, the staff may be focused on one narrow sliver of the business of a smaller firm with a overworked CCO, and so they say, oh, well, you didn't have policies and procedures around reverse convertible notes, which were less than 1% of the business of the firm, to pick a real example from my life. And we had to take that up to the most senior levels of the commission. They welsed the CCO in that situation, and then we got them to withdraw it and save the guy's job because we said, you'll never get anyone to take these jobs if you do enforcement actions in those circumstances where you're playing a game of gotcha. And I think it's really, I have tremendous respect for the staff. They reached the right answer in that case. But sometimes there's tunnel vision on the exam side and the enforcement side of, this is our priority this year. And so this has got to be the priority of the enforcement staff, of the CCOs, who may be sucking a fire hydrant on a bunch of issues that honestly are more directly affecting the clients of their firms.
You're trying to drink from a fire hydrant?
Yeah.
Oh, okay.
Yeah, sorry.
I'm just kidding. Just in the interest of time, let's if we could, close out with, first of all, I think, Kurt, you were going to touch on regulation best interest, what we're seeing there, and then, Ann, it'd be great to hear from you on, any thoughts you have for, words to the wise, tips for people to stay out of the. Nobody in this audience would enjoy having a conversation with you if they could avoid it out, in the course of your work. But personally, we love talking to you. So if you could give us some,
John,
yeah,
smooth.
exactly, some lines we could be aware of. That'd be great. So Kurt, you want to start with Reg BI?
Sure. I mean, look, in the broker-dealer space, and obviously we haven't covered much of that today, and we got 2 minutes left, but I think there are two issues. It's the care obligation under Reg BI, and it's AML. I think you heard on the directors panel a lot of discussion of AML. I think that is going to be significant. It's driven by everything from Russia sanctions, drug trafficking, you name it, there's an AML component to it. There was a risk alert worth reading from earlier in the summer focused on the KYC, the Know Your Customer provisions that I think you'll see some enforcement cases on. And you're seeing a steady stream of cases in that space against ATSs, the first, so we'll see if that's a start of a larger trend. And then the Reg BI care obligation guidance I thought was fascinating from April, in part because it was one release referencing the conduct of both investment advisors and broker-dealer reps in one release, which really tells you how much Reg BI has elevated that standard on the broker-dealer side. So those are the two things to keep your mind on, because I think that when there are fewer BD examiners out there, but those are the two things I think they're looking at.
Great. All right, Ann, how would you sum up the takeaways here? How do we avoid dealing with you professionally and embracing the opportunity to deal with you personally?
So what I would say generally is that the title of the panel was Financial Firms and the SEC's Crosshairs. And I think, there is some truth to that. We are looking at financial firms. Ultimately, though, when you're dealing with enforcement, if you come in and talk with me, we're reasonable people. We want to understand your businesses. We want to understand what happened in the situations we're looking at. And our ultimate goal is deterrence and protecting investors down the line. So I think the takeaway here is develop a really robust compliance program if you are a registered entity, or an internal controls program, and make sure that you are positioning yourself to be able to tell the staff that we took steps to prevent this, and it's just a mistake. You can't hold us to a single one-off mistake. We're a lot more likely to credit that if we see that you really have taken serious steps to prevent the kind of misconduct that we're seeing.
All right. Well, I think that brings us to the end of our allotted time. Thank you very much.
Very smooth.